everyone. Thanks for taking time to attend today's presentation. I am Diana Murray with ASAP Accounting and Payroll. And in today's presentation, we're going to talk about establishing and maintaining solid HR policies. And we've titled this webinar, Unpacking the Employee Handbook, because we really feel like the notion of a long, novel-sized handbook is a thing of the past. And rather, it's really important to create documents that speak to policies and procedures and separate out other documents such as time-off programs. So we plan to break this down and truly unpack this into some key areas of focus today. And really, to put it simply, every business, small or large, should have an agreement between all workers about what is accepted at work and what is not. And some companies have official policies written, and others, especially startups or smaller businesses, might share these expectations more holistically by actions or words. And so whatever your approach, we'll cover some key topics to consider as ground rules to set up your culture and reinforce your company's priorities. So that's what we're going to focus on today. A little bit of housekeeping. You can use the Q&A function in the Zoom webinar controls to ask any questions throughout today's presentation, and I will be monitoring those as we go, so feel free to type anything in there as we get started. And this webinar today is sponsored by ASAP Accounting and Payroll, and ASAP started in 1990. We're coming up on 30 years, and we started in Telluride, Colorado, but we have 3 regional offices across Colorado, including Telluride, Durango, and Denver. And really, our goal is to streamline processes, eliminate the hassles of bookkeeping, and mitigate risk, really so you can spend more time doing what you love. And here at ASAP, it's business as simple as possible. You can learn more about us and our team and our humble beginnings at www.businessasap.com. And with that, I'm excited to begin today's presentation, and I have Jessica Junker here with Cura HR. Hi, Jessica.
Hi, how are you?
Good, and just to give Jessica a little bit of intro, she's a native of the western slope of Colorado, and she works with Cura HR. Cura HR is a boutique HR consulting company based in Denver, and Jessica helps her clients with proactive growth and HR strategies, as well as overwhelming projects, and those scary HR issues like harassment and discrimination. So with that, I'm going to turn it over to you, Jessica. Thanks.
I'm Jessica Junker, and thanks for having me here. We're going to be talking about a few specific policies that I think are the most important, at least in my mind, for every handbook or every company to have within their employment policies umbrella here. And I'll start with maybe a little story, if my screen will work here. There we go. So this is a picture of me with my kids. This is last winter when we had that terrible ski season. And I was realizing that when we ran into this, not literally, thank goodness, but this sign that says, "You will hit rocks," it was sort of funny because it made me think about my very first business partner job in my HR career. An employee called or emailed to say, "Hey, can I meet with you? I need to meet with HR." And I was terrified. I did not know what this was going to be. I didn't know what the issue was going to be. I didn't know what to do or what to say when, without knowing what the employee's issue was going to be. I felt like I was flying down a ski hill with rocks everywhere, and what was I going to hit and what was I going to do then? So my analogy here is that practice helped, and so did having the right gear. One thing that I can say in terms of having the right gear is policies. I know policies are boring, and sometimes people roll their eyes a little and they say, no, we want to be flexible in our workplace, and I get that. I think it's finding the right approach for your own company's culture, but I think having a written policy on at least a few key things will help protect the business, protect the employees, and help build a culture that that's sustainable and positive here. If you don't have an official handbook, that's okay. You can still have official policies that are communicated. It's really about the communication and the expectations. Of course, if you have a handbook, or at Cura, we call them, instead of a handbook, we call them employment policies, right? We kind of carve out those key things, the key deal breakers, so to speak, that every organization should have. And that's what we focus on. So today we're going to cover a few things like harassment and discrimination, but honestly, policies, as I'm talking about these and documenting them, it applies to everyday things like dress code or attendance as well. So here's what we're going to cover today: equal employment opportunity, Americans with Disabilities, or ADA, and reasonable accommodations, anti-harassment, anti-violence and bullying, as well as our obligation to report and prohibition of retaliation. Again, these are the policies that I believe, anyway, that every company should decide is important, and they're dictated by federal laws as well. But regardless, I think that organizations, as we're trying to set ourselves apart, these are important things to communicate and to have in common with our employees to protect ourselves and our staff. So we're going to start with the EEO policy here. The EEO policy essentially prohibits unlawful discrimination on the basis of several statuses. And it's interesting because over time, those statuses have evolved based on different federal laws and cultural changes. We'll talk a little bit about those. So let's test your knowledge a little bit, and we'll take a poll. And I'm going to lean on Diana here to help me out on getting the poll set up through Zoom here. All right, this is great. Thank you. So what is not, that's the key here, not a protected class according to the EEOC? Again, the EEOC is the Equal Employment Opportunity Commission. This is multiple choice, and I'll give you a little hint that you may want to vote for more than one of these here. So we've got sexual orientation, genetic information, dietary needs, pregnancy, age 50 and up, or color. So please go ahead and mark any that you believe are not protected classes according to the EEOC. And when we're ready, I'll look at you, Diana, let me know, and we can kind of chat through what the answers are. This is not a test to show how much you don't know. It's more to show that that we're all sort of on the same page. Diana, can I put you on the spot? When we were talking about this yesterday, I said, so Diana, do you know the answer? And we chatted through, right? Because some of them were a surprise, and that's normal. Yep. I think. It's fine, because not everybody's supposed to be an HR expert, and that's why we're doing this.
Awesome. I've gone ahead and ended it, and I've shared the results here.
All right. So I see it on my screen. I'm not sure what everyone else is seeing. Can everybody see what we've got here?
Yeah.
Okay, awesome, yeah. Thanks. So we've got 100% think dietary needs is not protected. A few think genetic information, some sexual orientation, some pregnancy. Nobody voted for age 50 and up or color. So that means that everyone thinks that age 50 and up and color are protected classes. So let's start with dietary needs. You guys are right. That is not protected, not a protected class. So good job there. Genetic information is the one that people are surprised about. That one is actually protected. And I added it on here because again, it's one of the ones that surprise people often. And it's also one of the newer additions to what's protected class under the EEOC. What genetic information means in a nutshell here is any information including tests or genetic history, family history, or fetal tests for pregnant women that indicate that the person may be either, I don't know if the right word is ill, right, or have some sort of disability. Sometimes it could be, cancer or likelihood to have a heart attack, right? So when we say that we cannot discriminate based on genetic information, one good example is if we find out that our employee is likely to, or maybe not likely, what's the word I'm looking for? I'm going to use likely, even though that's not quite the right one I'm thinking of, but likely to have a heart attack, right? So we cannot change that person's job or put him or her into a different position because of that, because we're worried that he will or she will have a heart attack on the job. That would be considered discrimination. So that's what's covered by genetic information. I know that was a lot. I might pause after we go through all these and see if anybody has any questions on these before we go on. First, let's talk about sexual orientation. That also is one of the other more recent additions. Within this sex category, literally that's what they call it, is sex, the middle section here. The protected classes or categories within that category are sexual orientation, pregnancy, and gender identity. So all three of those fall under, they're in parentheses in the actual language of the EOC under the sex category. And then on the left, race, color, national origin, those three are kind of categorized together. We talked about disability. The one that people on this poll were off a little bit, you're on the right track. Age, notice it's 40 and up. And the poll, I had a trick question there, sorry to trick you here, but the poll had asked, that it had mentioned 50 and up. So that's the key here, I think, knowing what that threshold is, that 40 and over, you're protected. Also, we've got religion, military status, and genetic information. All of those we've touched on genetic information. Okay, so when it comes to your policy or your handbook, the fine print is, and I'm making it really simple here, is you want to make sure it's specified that you won't discriminate, your organization does not discriminate against, now this is a key here, applicants or employees, both, on the basis of a protected class. Now I do recommend that you list out all the protected classes in your policy itself. When it comes to applicants, usually handbooks are targeted to employees, but I still would include the word applicant in your policy because you want to make sure your recruitment and hiring practices are also not discriminated or potential discrimination here. So that's the fine print on your handbook or policies. Okay.
Hey, Jessica, I've got an entertaining question here.
Okay.
So if going back to that age category of a protected class,
yeah.
So does that mean that I can discriminate for somebody younger than 40?
Well, it's a good question. My sister is an attorney, and we had quite the conversation about this. So just because something is a protected class, that's what means that it's covered by the EEOC. Now, if you discriminate, it's technically possible to discriminate on other people who are under 40. It's not considered protected by the EEOC, so that's the difference there. I think that you don't see many lawsuits or any that I'm aware of, although I'm not an attorney, that are related to under 40. That's not something that is a high risk for litigation. So to answer your question, I mean, it's a yes and no, right? So I think what I would really focus on here is that as you're building the culture of your organization, that's, I guess it goes back to this, right? We're not going to discriminate against people in general, especially on the basis of a protected class, but really we just want to create good environments where everyone's welcome and comfortable, right? So that's kind of what I would focus on, even though maybe an attorney would have a more black and white answer for you. So our next one here is Americans with Disabilities, and I've kind of paired that with a reasonable accommodation commitment, right? So in the handbooks or in the employment policies documents that I help our clients create, I always call out the ADA, although quick side note, the law now is, this is kind of, dare I say, ridiculous, but it's some legal jargon. It's called the ADA, which is the Americans with Disabilities Act. And now they have an Amendments Act. So if you see ADA or if you see AAA, and I kid you not, it's really 3 A's at the end. It's all the same thing, right? And so I think many of us in HR, we just kind of shorten it to ADA instead of saying ADAAA. In your policies, you might use the full word or the full act to spell things out, just to make it, you know, in alignment with the law. But we'll talk about the act itself, and then we'll talk about what it means to provide a reasonable accommodation here. So let's start with what is a disability. So again, this is the legal definition, not my own here. So a disability is a physical or mental impairment that substantially limits one or more major life activities, has a record of such impairment, or is regarded as having such an impairment. So let's kind of break this down here. I think most of us understand what a physical or mental impairment is. So physical, I have a good friend who has scoliosis and spina bifida, and she had, had many surgeries, and she unfortunately is in a wheelchair, right? That's an easy to identify physical impairment. Mental impairments could be, depression is kind of the first that comes to mind for most people. That substantially limits. Now that one is sometimes arbitrary, and we can talk a little bit more about that when we talk about what the reasonable accommodations are. But substantially limits, you can't say, I don't know, I got a paper cut, right? It's a physical impairment, right? But that's not really substantially limiting my life activity, right? So that's where that substantially limits definition comes in. So the next piece here, it has a record of such impairment. So if I have had, what's a good example? Maybe if I've had shoulder surgeries, then I have a record of having had a physical impairment that, in that case, let's say, substantially limited my major life activity because I was, in a sling for 6 weeks, right? That may be construed as having a record, right, of such impairment. Now, it's interesting because you might argue, well, but you're healed, right? You don't, you're going to CrossFit all the time and you don't have any more issues. Well, okay, but maybe I still have some arthritis in there that you can't see, right? Or something else going on. So again, we'll talk more about how do you deal with those on a one-on-one basis, but that's what they're talking about, the record of such impairment. Now, this last piece, as leaders and managers, watch out for this one, or is regarded as having such an impairment. Now, this is an interesting one because, let's see, remember I used the example of the employee who had a history of heart conditions, right? So if I treat that employee as if he is disabled because I know he's had heart condition issues in the past. If I regard him that way, he is by definition disabled. Now, he might not think he's disabled. He might not be disabled, but as soon as the employer, I regard him as having an impairment, he's considered disabled, and that means he's protected by the ADA. So that's an interesting thing. Where you're going to see that come up most often is if you have an applicant. Let's see, I'm thinking of an example. Walk into your office for the interview with a significant limp, right? And you say, oh, do you have a disability? Or maybe you don't even say that in so many words. You say, oh, I don't know if you can do this job of being a bus driver because of your limp. Then that person, that applicant, is going to be covered by the ADA as being regarded as having such an impairment. Now, maybe that person just stubbed her toe on the way in, right? But as soon as you're treating her that way, it means different things according to the law. So let's see. Let's talk about providing reasonable accommodations, right? So reasonable accommodations, that should be in your policies, in your handbook, that we will provide reasonable accommodations. Now, those two words are important. You don't provide all accommodations, you provide reasonable ones. So really what that means is that we're going to do our best as an employer to enable our applicants or employees to do their job. So if I have, my friend Rachel, I mentioned in the wheelchair. So say she applied for a job that's on the 10th story or 10th floor of an office building, and the elevator is out, and the elevator is going to be out for 6 months for some crazy reason, willing suspension of disbelief here, right? So if she wants that job, she's obviously not going to be able to climb the stairs because she's in a wheelchair, right? So the difference of a reasonable accommodation versus an accommodation, any accommodation, right? There's going to be a different category or definition. So for example, you're not going to say that you have to force the building to repair the elevator today so that she can have the job. You might say, you know what, we'll find you a first floor office, or we'll let you work from home until the elevator is repaired, or some other thing. And often, maybe more than often, right? I think unless there's an exception I can't think of right now, I would put that to the applicant or to the employee and say, hey, Rachel, I know, I know you have applied for this job. The elevator's out. How could we accommodate you to do the job, to enable you to do the job? And she could suggest those things, and then we can decide, yep, that's reasonable, or you know what, maybe there's no office space, or maybe we don't have technology to allow employees to work from home. So maybe it's not reasonable, and every organization can make those decisions. A quick side note on reasonable accommodations is sometimes, remember in the EEOC, that chart, religion can be a protected, or is a protected class. So sometimes there are also reasonable accommodations that might be made for religious beliefs as well. One question I get a lot is, from organizations who are, in hospitality, or, some other businesses that run 7 days a week, 365 days a year, and the employee says, you know what, I need every single Sunday off for church. Well, do I have to give that to them? Well, I think it depends, right? Is it reasonable to have someone else cover for them on Sundays? Is it reasonable to have them work a different schedule? Are they the only person who knows how to do that one thing, and the job you posted was to work on weekends, and now they're applying for it and they can't work weekends? That's probably not a reasonable accommodation, right? So there's no black and white answer here as to what's reasonable, what's not. It depends on every situation. It depends on precedent, what you've done before, and what the employer, the applicant needs as well. So to recap here, 2 pieces for your policy. Make sure that you specify we don't discriminate against people with disabilities. Note that this is really generic. We didn't define what disabilities is considered here. That's intentionally left open, so it can include somebody with a visible disability, like the wheelchair example, as much as someone whose disability you can't see, like an employee with depression or cancer. And remember, it's every employee's or applicant's responsibility. It's not yours as the manager or the organization. It's the employer applicant's responsibility to request the accommodation based on their disability. So make sure that you let them kind of lead the way on that. You can always offer, do you have the tools with or without accommodations to do this job, as you show them a job description or the job posting, or as you describe the job. And then they can say yes, or yes, and here's the accommodation I would need. And then it's another further conversation to make sure you can accommodate that. And then the second piece to your policy is, again, we provide reasonable accommodations, which I think we've talked about. So I will pause there before we go on to harassment, see if there's any other questions.
I think we're all good. I think you, one of the questions that came in, I think you covered in terms of talking about reasonable and unreasonable. Mm-hmm. And I think even to hit it home more, as it relates to the job description, is an important element there too. So mm-hmm. Thanks, you can continue. Yeah. And I'm glad you mentioned that. One thing I did not talk about was the physician's role in that. So,
let me think, if an employee came to you and said, let's see, a recent example, I, as the employee, I got a concussion skiing last weekend. My doctor says that I can't look at my computer screen, you know, or I have to step away for 10 minutes every hour, or I need to sleep for, you know, 6 hours a day or whatever, right? In that case, or cases like that, it is advisable to go through what they call an interactive process, and I'm not going to go into that in detail, but really it's saying, okay, employee, tell us what you need and give it to us in writing from your doctor. We don't need the diagnosis. We don't need your protected medical information. We need to know what you're asking of us so we can tell you if we can accommodate that or not. And that's often a big help, because if the employee says, you know what, I need the next 2 weeks off, but their doctor's note says, nah, they can work half days for the next 2 weeks. Well, then that's a different conversation. And you can decide if you can or cannot accommodate that. But you're not taking the employee's word for it. And that's often a really good tool, so that you're not deciding, so that it's in writing that it's someone else's decision in terms of what the employee needs. So thanks for reminding me about that, Diana, and whoever asked that question.
Yeah, of course. We actually got another couple questions come in.
Good.
I think people start to think of all the
Yeah.
little things that come up.
For sure. Yeah. Yeah.
Let's see. So first one is it normal to have to address a reasonable accommodation when an employee returns from an FMLA 12-week absence that was taken for their own injury or illness? Do the two laws interrelate?
Oh, that's such a good question. And I, like with HR, it's sort of an HR joke where it depends is quote unquote the answer. I think the question is that happen often, or is that, I can't remember the word, but so yes, I do think that I don't know that I would say it's 50% of the time, but it's not unheard of where you know, I had back surgery, I've been off 12 weeks, and now I can come back, but I need different accommodations. I need a different chair. I need a standing desk, or, you know, I'm making these things up, right? And so yes, that is definitely seen. In terms of what do you do, it's the same as we've been talking about, where you can decide, is that reasonable? You know, a standing desk might cost $10,000, and no, that's not reasonable. But to allow the employee to stand up every 5 minutes every hour, if that's what the doctor says, then you can, I don't want to say what any of the people on this call could allow or not allow, but many organizations would say, yeah, that's fine. In terms of FMLA, often FMLA, which is Family Medical Leave Act, often that does act as actually an accommodation itself. So that if I, you know, say I have that concussion and I go to the employer and I say, I need to sleep 6 days or 6 hours every day, the employer can say, well, we cannot accommodate that. But look, we do have this leave program. We can give you the time off or intermittent time off, whatever your policy reads, so that you can get better and your job will be protected. So that often is where FMLA will come in as related to an ADA and accommodations. Is FMLA is the accommodation sometimes. It's a great example. And you had another one too?
Great point. Yes. So when you say that it's up to the applicant or the employee to initiate the request for accommodation, does that still apply under the pregnancy with the new Colorado legislation?
Great question. Yes. So so the Colorado law protects pregnant workers, pregnant women, women workers, I guess. But it's still up to the worker to say, I'm pregnant and, you know, I need to go down that process, right? I need the accommodations to be able to take time off to care for my baby and so on and so forth. So the pregnant worker still is responsible for, you know, going to you as the employer and doing the right paperwork or requesting the leave. You know, think of it as a really extreme example. So say she's pregnant and doesn't request time off, doesn't plan ahead, doesn't communicate with the manager and just one day doesn't show up because she has the baby, well, we're all happy for her and hope the baby's healthy, but that is not doing the job, right? She's still required to fulfill the expectations of the job, which are all those things, right? Communication and planning and following the policy, which I'm referring to your FMLA policy if you have one, or a leave of absence policy if you have one. And even if you don't have a policy for a leave of absence, you know, it still is a reasonable thing for you to be able to run the business and plan ahead. And I think if I'm reading what the question is can I go to her and say, hey, you told me you're pregnant, you know, what kind of accommodations do you need? And yes, absolutely, you can do that. Especially when she's communicated. I would wait until she's communicated it formally instead of making any assumptions, right? But yes, that is acceptable. Did I answer the question? I think I got it.
Yeah.
Okay.
Thank you, Jessica.
Yep.
All right, another good topic.
On to harassment. Are you ready for this? So like the ADA and reasonable accommodations, I've kind of bucketed these two in together, the anti-harassment and the prohibition of sexual harassment. Now, one thing I think I'll point out is often people refer to their harassment policies, and I've made a conscious decision to call it anti-harassment, right? And I know it's sort of funny to say, yeah, we have a harassment policy versus an anti-harassment policy. I think everyone knows what we mean when we say harassment policy, but I would recommend specifying that it's anti-harassment because you don't want harassment in your workplace, right? So harassment can be directed toward people involving the protected EEO statuses that we just talked about with that chart earlier. So from age to gender to race, or anything else in that chart we talked about. Sometimes harassment is obvious, like when somebody makes a comment about somebody else's religion or calls somebody a derogatory name. But other times harassment can be a result of different perspectives, and sometimes it can be unintentional. And that's where I think it gets tricky, right? Especially as an employer. So I have an example. This happened to me when I was HR manager at another organization years ago. And I did an investigation on harassment. So as I dug in, I learned a little bit more. It's sort of like an onion, right? So what originally came to me was that an employee, and we'll call him Jim, was discriminating against another employee, and we're just going to call her Amy, right? And that Jim was allegedly making discriminatory comments about Amy's race and ethnicity. So when I talked to Jim, I started by digging into, what happened, what's your side of the story? And he said that he and Amy had been talking about their favorite lunch place. And Jim asked Amy if she liked Chinese food because her family was from China. And he didn't realize that Amy was offended. He actually thought that she was amused, right? And he thought that they had something in common, right? He thought that they were both talking about this great restaurant down the street and they could go there at lunch. And he didn't understand, according to him, that it was rubbing her the wrong way. So I go back to Amy again and find out a little more. And she said, you know what, okay, I agree. At first, I initially was not offended, but over the next couple of weeks, Jim didn't let it go. So Amy explained that Jim would comment about not only just Chinese food and the Chinese food place, but he brought it up every day. He started using fake accents. The final straw is she said that I walked into the break room over lunch one time, and he pulled me over. He says, you got to look at this. You got to watch this video. And he had his smartphone pulled out, and he showed her his favorite South Park episode, which poked fun at Chinese people. I'm assuming people know about South Park, but if you don't, it's this kind of raunchy cartoon which makes fun of virtually everyone, every category, right, in the essence of it. But when he pulled out that smartphone and made her watch it, she felt very uncomfortable and discriminated against, right? So so it's all about perspectives, right? And if we would have stopped that story halfway through, sometimes things can be unintentional. It's just learning taking cues and learning when to stop here. So let me give you another little example, a silly little Dilbert cartoon. So she says, "Hey, Ted, are you free for lunch today?" And he yells like, "I'm happily married, leave me alone." And he's all worried about it. She says, "Relax, I only want to network with you." Right? So again, it's silly, right? But it goes to show that perceptions can differ. Communication can help. So make it known if you're upset about something or something rubs you the wrong way, that's not okay, and that behavior should be stopped immediately. As leaders and managers, that goes to another level, right? As soon as a leader of an organization is aware of something that could be perceived as discrimination or harassment, you have to do something about it. And maybe that's just clearing the air and say, "Hey, she was just asking you to lunch, you know." she's not doing anything inappropriate, and making sure everybody's on the same page. So one lunch invite might be okay, but when we're talking about harassment or discrimination, I put things into two categories. One is severe, and the other is pervasive, right? So if in this cartoon, if she pinched his behind while she was asking him to lunch, that's severe. If she asks him to lunch every single day, and he says no every single time, that's pervasive, right? And in both of those would be a different situation than if it's this one-time example in this cartoon. Okay, so knowing your audience and knowing when to stop are key. Talking about Chinese food restaurant spots is fine. Crossing the line to mimic or ridicule or to not let something go is not fine. So here's another little example, thinking of it a different way. So picture me sitting with my college buddies. I'm watching my favorite football team, and they make a bad play. And so I might roll my eyes and I might call them idiots, right? I might jump up from the couch and wave my fist. The next weekend, say I'm watching my 10-year-old at the school play, and he gets his lines wrong. I'm not going to stand up and wave my fist and say, "You idiot," right? So it's about knowing your audience, and it's about knowing where you are and who you're talking to and who you're talking about. So I think one of the questions I get from employees sometimes is, "You know what? I was with people I'm comfortable with. I was at work, and our environment it allows kind of being a little, teasing or what have you." And so I think it's always that balance. So yes, it's good to be yourself, but know your audience, and then be the work appropriate version of yourself, right? Just like my football and school play example, I'm still the same person, but I'm being appropriate to the situation that I'm in. So in other words, don't assume that behavior is not offensive to you. Don't assume that if it's not offensive to you, that it is acceptable to others. And I think this is a big takeaway. Harassment is often defined by the person receiving it. So keep that in mind. Again, with your leadership hat on, it's not just you personally. It's if you witness something that maybe you're not offended about, but you think it could be interpreted different ways, go pull somebody aside and say, "Hey, you know what, that was, I understand why you said that, but it might have rubbed somebody the wrong way." So the fine print for your anti-harassment and sexual harassment is we treat other people with kindness and respect, and unwelcome sexual advances or other conduct of a sexual nature are prohibited. That's what I would include in my policy if I were you. Anti-violence and anti-bullying, and I'm going to keep going unless there's any questions, right, Diana?
Yeah, charge on.
Okay, off we go. So I recently read a story on social media. The parent came into the teacher and says, "My daughter is being bullied on the playground." The teacher was saying, "Okay, no problem. I'll go look into this and I'll get back to you." So the next day, the teacher calls the parent and she says, "You know what, there's no bullying going on." And the parent says, "Well, okay, how do you know?" And the teacher says, "Oh, I stood out on the playground at every single recess and I didn't see any hitting or punching." So if we were all live, I would look around the room and ask you how you would define bullying, like what some examples are of bullying or violence. Since we're all on a webinar here, I guess I'm going to show my cards. You know, I think when we think of bullying, often it's punching or hitting, even use of weapons, stalking, name calling, you know, that kind of physical aggressive stuff. These are good examples of bullying for sure. But there's also bullying that can be less obvious, both on a playground, but honestly at work too, right? So some examples are gesture bullying. These could be nonverbal gestures or even glances that convey threatening messages. You know, eye rolling, for example, or body language turning away from people. Exclusion is another example. So socially or physically isolating or disregarding a person in a work-related activity. So that means even not inviting somebody to a meeting, or it could be if you do happy hour every Tuesday and you invite the whole department but one person, you know, those things are considered bullying. I know it's really hard, right? Especially as leaders, because you want to treat your team to lunch. You want to, you know, give a gift at an anniversary. You want to give a pat on the back, but make sure that as you're doing that as a leader, you're not inadvertently doing one of these things. I'm not saying that you'd be bullying, but it could be perceived as, you know, excluding employees if you invite some to lunch but not others. And it's hard. It's hard being a manager sometimes, but it's I think one of those things where if you show as a leader how to act, then the other employees will follow suit here. Let's see, so think about our earlier example about the Chinese food conversations. So again, we talked about part of the definition is pervasive, and part of it, so I guess in this example, right, of bullying, if you had a conversation once, then it's different than if the conversation keeps going on and on and on. That also may be considered bullying. Also remember, one size doesn't always fit all. We talked about this before too. Sometimes there can be comments or stories or you know, some conversation that can be intended as a joke, but it could be perceived as another person as violence or bullying as well. So the fine print, make sure in your policies you specify that we don't allow violence or threats of violence, including bullying, which includes persistent malicious behavior, which offends, intimidates, or humiliates another. Okay. Obligation to report. So these last two sections here are pretty quick, and then I think we'll have some time for more questions if we have any here. So these last two policies here are important. Now, the first four sections we've had are, I think, important policies, some of them for legal reasons, others for cultural reasons. Obligation to report is one of those that is a must-have, not because some organization like the EEOC or the ADA says you have to have this, but because it's the right thing to do. And it protects you if you have a reporting policy. It protects you if there is some sort of issue, right? So if you have an obligation, let me go to the next slide. If you have a situation that comes up and you have a reporting procedure, and employees use it, you know, they go to, whether it's HR if you have HR, or to the supervisor, or to the manager, or to, you know, some other identified position, that can nip things in the bud way before it escalates out of control and people are, you know, they quit or they're fired or they file an EEOC claim. So I think that it's important to share with your staff that it's their responsibility, each employee's responsibility to abide by the policies that you have in your organization and any laws that apply, and to specify that if they believe that there's been a violation of any expectations, that they're obligated, and that's a key word there, to make a timely report. Back in the day, so to speak, organizations might have reporting policies, and you can tell I changed this right here again, obligation to report. So it's now not just saying, hey, you can report, but it's saying, hey, as an employee here, you we're expecting you to report if you hear of things that aren't appropriate, because we as an organization, we care about what happens here, and we care about having employees be in a workspace that they feel comfortable in. I literally cannot tell you how many times I've spoken with employees as an HR person who didn't report something the very first time it happened, and the situation just got worse. I get it. It's hard. Often, there's fear, or there's shame, or there's, it's uncomfortable. But if your employees know what the process is for reporting, I promise it will help, because as soon as you as a leader, know what's going on there, then you can do something about it. In your policy, I would recommend having at least 2, as in multiple different resources, right? So often I say, report to your supervisor as your first line of support, and then I'll list 1 or 2 other people. Often it's, HR, your supervisor, HR, or the owner, or the CEO, or the, COO, or maybe it's even quote unquote other senior leader. I would not put in names, because if that person, leaves the organization, or if they change their role within the organization, then your policy is outdated. So put titles instead, but make sure you have a couple of different options. And I mentioned this already, right? The first line of support is an employee's own supervisor. And I think this is key too, to making sure that the supervisors that you work with, or who are in your organization, are trained on, all right, so this employee just told me that, that another employee has asked her about Chinese food, 5 days in a row, but the supervisor doesn't do anything about it. And that's just as bad or worse than if the employee didn't report it in the first place. So making sure the supervisor knows what to do, or who to go to, or what to say. And often that might even be, hey, employee, I hear you. I don't have an answer for you right now. Let me look into this, and I'll get back to you by the end of the day today, or by, Monday, or whatever. And then it's okay to say, I don't know, and I'll look into it. It's just the follow-up that's the key to that, because if they don't follow up, again, it makes things worse in many cases. So your policy fine print here, we not only allow you, but we expect you to report incidences that are in violation of our policies. We have multiple resources for escalations, and they are this, and this within your organization. I'm pausing, Diana. Keep going.
Keep on going.
All right. So our last section here is our prohibition of retaliation. So it's similar to the harassment. Instead of saying we have a retaliation policy, it's that we prohibit retaliation, right? So when we investigate reports, and I mean that as HR people, but managers, leaders, anyone, right? When there's something that's going on and we look into it, we do our best to protect the people involved. But let's be honest, sometimes the questions that we ask during an investigation might lead others to make assumptions about, what's going on, or who was involved, or who reported them. So I would never say I can guarantee you confidentiality. But I do say, and would suggest you also say, that I will do my best to keep this confidential, but I can't promise anything. However, we do have a very strict policy against retaliation. So anyone who makes a report, raises questions or concerns, or participates in an investigation will not be retaliated against. That should be in your policy. And if employees do perceive retaliation for any reason, then they need to report that up. And I would specify that we take this seriously. In my mind, this is a deal breaker, because if people don't feel like they can come forward, they're never going to come forward, and you're not going to get anywhere. I have one last example here. It was a fairly recent investigation that I did, and I'll spare you some of the details, but basically the employee accused her manager of a romantic relationship with another employee, right? So I investigated, and as it turns out, there was no relationship. I was able to substantiate that it didn't happen. So nothing happened, right? So I documented that we looked into it. Nobody did anything wrong. No one was written up. Nobody was fired. Nobody was coached. So theoretically, that's the end of the story, right? Well, sadly, the manager who had been accused thought that he knew which employee had, as he put it, tattletailed on him. And so he changed her schedule. He sent her home early. This was a retail role. And so she wasn't getting as much pay because she wasn't working as much hours. Well, the funny thing is he was wrong. He guessed it was one person and really was someone else altogether different, not even involved, who he was retaliating against. So as we investigated that, he ended up being fired for that retaliation of someone who hadn't even been involved in the original situation. So, it's unfortunate, right, that somebody could go through an investigation and only to, make their own issue later to be fired. But let's see, remember that retaliation can come in many forms. So it's anything I mentioned, taking shifts away, withholding promotions, firing someone, but basically it's not acceptable. And so make it clear that to your employees that you will protect them. It does not mean that if I raise a report and then it doesn't mean I can come in late to work every day for the next week because I'm protected, right? I still have to do my job, but I couldn't be treated differently because of that report. So that is that. Let's do a quick recap. EEOC or EEO, treat people equally, don't discriminate. ADA-based decisions on job requirements and abilities. Anti-harassment, be respectful and know your audience. Anti-violence, sometimes it's clear and sometimes you need to know your audience, but it's never tolerated. Obligation to report, make sure there's an expectation that people speak up if they see something going on. And prohibition of retaliation, make it clear that employees are protected from, that doesn't make sense, does it? Protected from coming forward, protected if they come forward. So that is it. Hopefully we are helping you, quote unquote, avoid the big rocks with some of these policies. And I will stop there. I know that we're right there at 3 o'clock. I'm sorry I didn't leave a little more time here, but any last minute questions?
Thanks, Jessica. I'll leave a couple of minutes for people to ask questions here. And while we're waiting for people to type in their questions, I did want to share that while ASAP has a number of kind of library resources for our clients through our online HR support center, every situation is different, every company is different. And so when you need to get into the weeds of your specific areas, or when you get into these sticky situations, that's when partners such as Cura HR come in handy for our clients. So I'm really grateful for Jessica's time and for Cura HR for their partnership with ASAP. So thank you, Jessica, so much.
Yes, my pleasure.
It looks like we have no questions, so we'll go ahead and spare everyone's time. And again, thank you so much for your participation and your time today. We do record all of our webinars, and we have a number, be sending this recording to you, but we do have a number of great resources on our website under our webinar archive and our blog, and also our knowledge base online on our help center. So again, be sure to check out all of those resources that ASAP tends to provide for our clients. So thank you so much, everyone, and have a great day.
Great, thank you.